Hello friends, today we're talking about section 52, that is transfer of property pending suit relating thereto. In layman's language, this is referred as lis pendens. Lis pendens, let us understand what is the word lis pendens. Lis is a dispute and pendens is or pendency is pending before the court, a dispute pending before the court. Now let us understand what is lis pendens. Any suit pending before the court. Let us have an example to understand it much more better. If a suit is pending before the court, suit or a proceeding is pending before a court, and when the matter is pending before the court, any party to the suit conveys the interest in the suit to some other person. The person who receives the interest in the property will be receiving the interest, subject to the outcome of the suit. In other words, what is the ultimate decision the court passes? The same interest or same result which the person are litigating will go on to the third person. That is meaning of lis pendens. Now, what does section 52 say, or what is the requirement of section 52? That a suit should be pending before a competent court. When I refer to competent court, it refers to a court where the property is situated. Now, when you refer to competent court, the property may be in Bangalore, and you cannot file a suit in Chennai. In other words, the court is competent to entertain the suit is a Bangalore court, not the Chennai court. In case you file the suit in Chennai, the suit will be dismissed only on the ground that the court has no jurisdiction. And the word Jammu and Kashmir, which is referred here, Jammu and Kashmir, is this act was made way back in 1882. So at that point of time, this act was not applicable to Jammu and Kashmir. Now, virtue of amendment, the virtue of revocation of Article 370, even Jammu and Kashmir, this act has been made applicable. And the suit should not be collusive. If the suit is collusive, this section will not be applicable. In order to defraud a third person, both the plaintiff and defendant file a collusive suit, or after filing of the suit, a suit may be not collusive, but after filing of the suit, both the parties come to an understanding to defeat somebody's interest, become collusive together, have an ulterior motive, defeat somebody's interest, then also the suit may become collusive. And in such cases, Section 52 may not come into play. And the interest which you are conveying to the other person should be directly and specifically in dispute before the court. So this is what is dealt in Section 52. And in case there's an urgency to dispose of the matter, any other person wants to dispose of the matter, he can make an application to the court. And the court may, you see the word may, and the word, whenever a word may is used, which is discretion of the court may allow the application on such terms, on such cost. Now let us see when does the proceeding before the court commences and when does it come to an end. As you all know, anything has to start and come to an end. So pendency of a suit, when does the suit commence? The moment you file a suit in the court, the moment you file a complaint, in a criminal case it is called complaint, in a civil proceeding you call it a suit. So whenever you start proceeding, you file a suit in the civil court, and the suit is continued, and it is disposed of ultimately by way of an order. And in case you file an appeal, the suit is continued because appeal is a continuation of suit. And on termination of appeal, and after the decree is passed, and decree becomes final if it is not challenged. Then the order of that court becomes final. This is what is meant by unobtainable. Unobtainable. So here you come across the word unobtainable. The order becomes final, and on expiration of this order, the person who gets the order, it has become unobtainable. That is what it is meant. The order becomes final. The commencement is when you file the suit, and it comes to an end when the order is unobtainable. You cannot enforce the order. Even if you file an appeal a day late in the day, 1 day late, that is limitation time for filing an appeal may be 30 days or 60 days in a given case. If you file even 1 day after 60 days or 30 days, the order of the trial court or the appellate court may become final. This is the ultimate explanation given in the explanation part of section 52. Now, what are the leading cases from examination point of view? Jairam versus Ayar Swamy, AAR 1973, Supreme Court 569, which says in a case of partition, principle of principle of section 52, lis pendens will not be applicable. And in the case of Supreme General Films Exchange versus His Highness Maharaja Sir, AAR 1975, Supreme Court 1810, in a case where the lease agreement had to be was being in dispute, and in between a transaction had taken place. The court said a principle of lis pendens was applicable and section 52 was hit in that case. Now, what are the conditions applicable for to consider that it is hit by section 52 of the Transfer Property Act? There should be pendency of a suit or proceeding. That is, a suit or proceeding should be pending before the court. And the court should be competent jurisdiction, as I told you, where the dispute arose, that is, the property should be situated in the same place, and the court also should be in the same place, that is, Bangalore court, and the property should be in Bangalore. Suit or proceeding should not be collusive. It cannot be a collusive suit. If it is a collusive suit, the suit itself is infraction. It is bad in law. Right in immovable property must be directly and specifically in question. Property in dispute should be transferred, must be transferred or otherwise dealt with by any other parties. Alienation must affect the right of other parties. In other words, when the person alienates the property when the suit is pending before the court, the right which has been transferred during pendency of the court will affect the right of the other person. This is the ultimate uh, ingredients of section 52. So by this, I conclude my session. Thank you.